Good afternoon and welcome to everybody. I'm Kate O'Regan. I'm the director of the Bonavera Institute of Human Rights at the University of Oxford, and a warm welcome to you all to this Bonavera discussion group, and particular welcome to all of those who are people from the Price Media Moot community. We're always delighted to have you here at our events. So today we're going to be talking about data protection law, and we're delighted to welcome Dara Hallinan from the FIZ Karlsruhe Institute, who is a specialist in the intersection between law and new technologies, and particularly on ICT and biotech. And he's going to be presenting a paper on the concept of information in data privacy law. And we're also delighted to welcome our own Bonavera research fellow, who's also a tutorial fellow in law at Wadham, Oliver Butler, who also works in the field of data protection and who will be responding to Dara in due course. So Dara, I'm going to hand over to you. Thank you.
Well, first off, thank you very much for the invitation and for setting this up. I would jump straight in. I think I would like to share my screen. So if be great if you could just indicate to me whether you can all see the presentation. Yes.
Yes, all good. Thanks, Dara.
Perfect. Right. So two concepts of information in data protection law. Information is a really key concept in European data protection law. It's the processing, storage, further processing, manipulation of information, the information society, which really gives data protection law its reason for existence. Despite the significance of the concept, there's almost no scholarship or jurisprudence dealing with its boundaries or its functions. We engaged in a preliminary investigation of the concept, and what we found was a concept which is complex, multifaceted, and eventually can be regarded as a problem in the way it's currently conceived for data protection. In this regard, what I want to do today is present three theses that emerge from this preliminary investigation. One, that there are in fact two different roles played by the concept of information in data protection law. Two, that the substantive boundaries of the concept of information populating these two roles are different. So these are really two different concepts that actually don't relate to the same substantive phenomena in the world, so to speak. And three, that the differences between these two concepts of information, so the two concepts populating the two different roles, constitute a problem for the efficacy of data protection law. So in relation to thesis one, that the concept of information plays two roles in data protection law. In its first role, information is an applicability criterion for the function or for the applicability of European data protection law. So the most important applicability criterion in European data protection law is the concept of personal data. More or less, when personal data are processed, data protection law will likely apply. One of the key constituent criteria within the concept of personal data is the concept of information. So in order for some substance or some entity in the world to constitute personal data, it must first be able to be regarded as information, as the term is used in data protection law. Now, in this role, the concept of information has been designed to be interpreted in a highly, highly flexible manner. And essentially, it's been designed to be interpreted to allow data protection law to flexibly apply to a wide range of situations in which the use of depictions of individuals, and I use the term depictions in a very, very broad manner, can potentially cause risks to individuals' fundamental rights in the information society. Whilst the first role is the role that everybody knows, it's explicit in law, everybody talks about, there's also a second role for the concept of information, and that's information as an object of regulation. And in this role, information is the substance, the entity in the world in relation to which the concrete principles, the concrete provisions of data protection law were designed, and in relation to which, or around which they were designed, and in relation to which these are intended to act. So in relation to which these are intended to have some kind of channeling function. And in this role, the concept of information is much less flexible, as it's essentially pre-baked into the concrete provisions which appear in data protection law and their subsequent jurisprudential interpretations. So this brings us on to then the second thesis, that the concepts filling these roles actually don't converge on the same substantive phenomenon. In order to demonstrate this thesis, what you would really ideally need is a framework for mapping and comparing the boundaries of the two concepts populating the two different roles. Now, the problem you immediately meet in relation to this necessity for a structured framework for mapping is the fact that there's been very, very little legal consideration of the concepts, very little academic consideration of the concepts in data protection law. So there's no structured framework which is readily available to engage in this task. And to go around that, what you need to do is then to try and build a framework using information from other sources or other forms of conceptualizations of information. And fortunately, information, as a concept of information, has a rather long history and appears in a great many other disciplines. So in relation to these other disciplinary concepts of information, in order to build a framework, we might start to do is to look across these various disciplines in which the concept of information appears and identify commonalities between these conceptualizations. And then in relation to each identified commonality, you might try and build an axis along which to plot the differences which have been taken in the approaches in each different disciplines. And then that set of axes together can function as a structured framework against which the concepts of information in the two different roles in data protection law can be mapped. So when we engaged in this exercise in attempting to build a structured framework for the identification of the substantive boundaries of concepts of information in data protection law, we came up with a framework consisting of three key axes of differentiation. Now, the first axis concerns the relationship between the concept of information and the transmission of meaning about something in the world, or put differently, the reduction of uncertainty about the world. In this regard, there are certain concepts of information which are ambivalent to the transmission of meaning, certain concepts of information that appear in maths or indeed in computer science. Other concepts of information, however, relate solely to the reduction of uncertainty, the transmission of meaning in the world. And even within these definitions, which relate to the transmission of meaning in the world, there are significant differences as to the degree to which a substance must be pre-structured in order to provide meaning to one or more groups of recipients. So certain concepts of information require that information has already been, or the substance in question has already been churned, the informatic substance in question has already been analyzed and reduced down to something that can be understandable by a recipient, whereas others are ambivalent to this and require only that the substance in question is potentially capable of being analyzed such that it eventually can transfer meaning. The second axis then concerns the relationship between the concept of information and the media of storage and transfer. So certain concepts of information are completely open as to the media of storage and transfer, whereas other concepts are actually quite closed in relation to the media of storage and transfer. So there are conceptualizations of information in computer science, for example, or informatics, which are quite specific as to the need for, in order to identify information, that the substance in question is being processed within computer systems. And then on the third axis, concerns the relationship between the concept of information and human cognition. So certain concepts of information are completely ambivalent as to any role for human cognition at all. So there are, for example, certain philosophical expositions of what information can be, which perceive the possibility for information to exist in the wild, irrespective of the perception by humans at all. And the quintessential example of this is the rings in tree trunks, which represent the ages of trees. So if a human has not cut open any given tree, they've never perceived the rings, yet these might still be recognized as information in the wild under some conceptualizations of information. Other concepts, however, are far more specific, that human cognition must have played some role in the curation of the substance in question. So against this framework, or this framework at least, then can be used to map the substantive boundaries of the concepts of information, fulfilling the two different roles for concept of information in data protection law. And what happens when you map these two concepts is the following. In relation to information as an applicability criterion, taking into account the purpose of the concept, so the purpose of the concept of information as an applicability criterion in relation to risks to individuals, as well as the fragmented and sporadic jurisprudence which is available on the concept, you get the following. Along axis 1, concerning the transmission of meaning, the concept of information essentially encompasses all types of substance capable of meaning transmission, regardless of the degree to which these have been structured or must subsequently be structured in order to transmit meaning directly to one or more parties. So it doesn't really matter if the substance in question is in the form of a raw data set or in the form of highly structured social facts. Along the second axis, what you find is that the concept of information encompasses all types of informatic substances stored on all forms of storage and transfer media. So it's ambivalent as to where, in what form the information or the informatic substance is stored, and in what form or in through what media the informatic substance is then subsequently transferred or processed. And along axis 3, you find that this is a concept of information which encompasses all substances, all informatic substances, provided that they are processed in a context for which human cognition has played some role in establishing. So then moving on to the information, or the concept of information as an object of regulation, taking into account the dimensions of the concrete provisions in data protection law, and then working backwards to the assumptions that must be true about the concept of information in this second role, such that these functions make sense and such that these functions make sense. You get the following. Along axis 1, concerning transmission of meaning, you find a concept of information which relates only to informatic substances which are capable of transmitting meaning, but only to informatic substances within that group which are already structured such as to provide meaning directly to one or more specific recipients. So essentially social facts. Along axis 2, concerning the media of information storage and transfer, what you find is the concept of information which encompasses all informatic substances processed in media which facilitate relatively frictionless storage or transfer or copying and transfer of information. So not all media, but only media which facilitate frictionless copying and transfer. And then along axis 3, concerning human cognition, you find a concept of information that requires that human cognition has played some role in setting the processing context, but also which requires that the informatic substance in question must be capable of being perceived and understood by humans. So just to wrap that up briefly, and to compare the two roles, or to make explicit a comparison between the two concepts, to demonstrate that they actually map to two separate substantive phenomena. What you have along axis 1 is that information as an applicability criteria refers to all substance, or is capable of encompassing all substances which can function to transmit meaning in the world, whereas information as an object of regulation only relates to highly structured informatic substances, really in the form of social facts. Along axis 2, what you find is that information as an applicability criterion encompasses all storage and transfer media, whereas information as an object of regulation only encompasses media which facilitate frictionless storage and transfer. And then along axis 3, what you find is that information as an applicability criteria requires human cognitive involvement in setting a processing context, whereas information as an object of regulation also requires that a substance must, or an informatic substance must be capable of being perceived and understood by humans. So there are definitely differences if you engage in this mapping process between the two concepts. And that's all very nice and quite interesting and quite neat. But it does raise the question, does any of this actually matter? Do these differences matter, or is this a completely academic line of inquiry? And that brings us to the third thesis, that the lack of convergence between the substantive boundaries of the two concepts of information, filling the two roles of the concept of information in data protection law, is actually significant for the function of data protection law. I want to demonstrate this by providing examples of problems that emerge in relation to differences along each axis. So an example of then the significance of the differences between the concepts along axis 1 is provided by a consideration of the processing of human genomic sequences. So human genomic sequences are capable of being analyzed to produce socially relevant facts about individuals. A whole series of analytical frameworks that can be applied to human genomic sequences to produce facts. That's very clear. However, the full range of facts which can be produced about individuals expands unpredictably over time as genetic science advances. And it's very clear that human genomic sequences fall within the concept of information as an applicability criteria. There's even jurisprudence on this. Whereas it's also clear that human genomic sequences don't fall within the concept of information as an object of regulation, because they're not pre-structured in the form of a specific set of facts. They need subsequent analysis to generate facts which can then be transmitted to one or more groups of recipients in a form that they can understand. So essentially what you have is that human genomic sequences fall within the scope of data protection law, but don't constitute the substance around which the provisions of data protection law were designed to apply, or to which the provisions of data protection were designed to apply. And there are several concrete provisions in data protection law. And in this regard, there are a number of provisions in data protection law which require a data controller, so the person who processes personal data, to provide information to the data subject, so the individual potentially impacted by the processing of that personal data, or about whom that data, that information says something, about this processing, such that the individual can understand the consequences of processing. And this transfer of information from data subject to individual should happen in a one-off manner, so that the information is accurate both at the time that it's given to the data subject and for the whole duration of processing. Now, in this transmission of information, the knowledge of the relevant semantic content that can be generated from the substance under question is really important for the individual to evaluate the consequences, or the social consequences which might accrue from the processing. So it makes a big difference whether somebody is processing your shoe size or somebody is processing your life history. However, these provisions which mandate this one-off transfer of information, they can't really work effectively in relation to genomic sequences, as the semantic content in the substance, in the genomic sequence, is liable to expand unpredictably over time as genetic science advances. So there's a gap following the provision of the information to the individual and the subsequent possibility to generate more information about the individual from the genomic sequence that's not covered by the concrete provision in the law currently. So then an example of the significance of differences along axis 2, that should say axis 2, but it doesn't, and that's biological samples in medical research. So there are a number of contexts in medical research in which biological samples are collected in order to extract the information about individuals they contain, such that this information can then be used in medical research. Now, it's very clear that biological samples can fall within the boundaries of the concept of information as an applicability criterion. Again, there's some jurisprudence on this, but they don't fall within the boundaries of the concept of information as an object of regulation, because they don't facilitate the easy storage and transfer of information. Now, there are several, in this regard, there are several concrete provisions in data protection law which require that data controllers provide data subjects or another party demarked by the data subject with a copy of their personal data being processed. And these provisions were never intended to be associated with particularly significant burdens on data controllers. They were meant to be very easily executable and without particularly high resource investment. However, when these provisions are applied to human biological samples, data controllers are faced with significant burdens. So either data controllers are obliged to sequence the sample, so actually go through the whole genomic sequencing process to be able to provide the final electronic version of the sequenced genetic information contained in the sample, and then send this in electronic version to the data subject. Or they're obliged to actually engage in a process of physical copying of the sample. So there are a number of ways you can make an immortal cell line out of one single cell, and then send that to the data subject. And both of these approaches, or both of these possibilities, are highly resource intensive. And then an example of the significance of differences along axis 3 is provided by advanced analytical technologies, for example, neural networking. So in certain constellations, personal data is processed in such systems that can make it very difficult or even impossible for humans to access, perceive, and evaluate the content of information being processed. So neural network systems is one example. Now, substances processed within the context of these systems certainly fall within the scope of the concept of information as an applicability criterion, and this is information processed in a context set with human involvement, but they don't necessarily fall within the scope of the concept of information as an object of regulation, as they aren't susceptible to human perception and understanding. And in this regard, there are a number of provisions in data protection law, really numerous provisions in data protection law, which require that humans are capable of engaging in the evaluation of the informatic substance being processed against some socially defined benchmark. And these become really, really difficult to apply, or it's very difficult to understand how these should rightly apply when humans can't perceive or understand the substance being processed or flying around in the system. So for example, there's an accuracy obligation in data protection law. How is it possible to effectively apply an accuracy which requires that the data controller process data, store and process data accurately in all situations? But how is it possible that a data controller can evaluate the accuracy of informatic substance or personal data flying around a system when they can't actually perceive or understand the data flying around that system? So those are three examples of issues which emerge as a result of this fundamental discrepancy between the boundaries of the two concepts of information in data protection law. And I believe this lack of convergence, as well as the range of consequent problems, will likely grow over time. This is as a result of the fact that the concept of information as an applicability criteria is far more flexible than the concept of information as an object of regulation. Now, as information processing becomes ever more important in society, which it seems to be doing, novel forms of information or informatic substances with novel qualities will likely continue to emerge. And many of these will likely be capable of impacting individuals' fundamental rights and will likely then fall within the former definition of information as applicability criterion. So they will fall within the scope of data protection law, but they won't necessarily constitute the substance around which the concrete provisions of data protection law were designed. Precisely what problems that will cause is largely crystal ball gazing, but that it's likely to cause further problems in future seems quite clear to me. So in conclusion, information is a really important concept in data protection. In fact, it's an absolutely central concept in data protection law. However, the boundaries and functions of the concept have scarcely been considered in either jurisprudence or academia. So a preliminary investigation, however, reveals a concept occupying different roles in data protection, which is conceived in different ways depending on the role, and which is actually the conceptualization currently of which can be seen as functionally problematic for data protection law. So I have slide on further perspectives or further avenues for research, but I think I can just leave that up, and I think I've probably spoken for about half an hour. I'd pass it on to Oliver.
Thanks very much, Dara. I think it might be a good idea actually to take it down so people can get a better view of people of people who are speaking, if that's okay. Thanks, that was really interesting. Oliver, are you there?
So I think, first of all, to say thank you for a fascinating paper and presentation. I thought it was a really, I've read the paper on which this presentation is based, and I thought both of them were excellent. So this presentation deals with a foundational yet underexplored aspect of data protection law. And it raises issues that have, I think, particularly acute consequences for emerging technologies, and you trace out some excellent examples in relation to human genome sequencing, also in relation to machine learning technologies based on neural networking. So we're really fortunate to have you speaking today, because you're particularly well placed to comment on those topics, given your broader work in this area. I'm looking forward to the Q&A. In my response, I'd like to comment on what I see as the main strengths of this presentation, and then pose some questions about whether and when a tension between information as an applicability criteria and information as the object of regulation could in fact be desirable, rather than raising a problem of efficacy for the GDPR. So that's, I suppose, to ask whether this tension that you've identified might be a feature rather than a bug of the GDPR, even if it's an unintended feature if we look at the history of its development. So, and also I think it's important to ask whether that answer varies depending on the type of information, and therefore the type of processing that would be excluded by the implicit requirements of information as an object of regulation, but would be within the concept of information as applicability criterion. So it would be within the scope of GDPR, but the particular processing would be impossible under it. So in short, is the divergence between the two conceptions always problematic for the purposes of data protection?
Sorry.
Sorry, yeah, would you prefer me to take the points and then sort of, there's quite a lot of questions for you now. Right, so first I think the presentation is really impressive in drawing out these different conceptions of information that underpin the GDPR. As you say, it's underexplored in the literature, it's given little explicit consideration in the case law, either the GDPR or the ECHR. And despite that, it's rarely been raised as problematic. In most situations, of course, it's straightforward to identify that something is information, both in terms of the applicability criterion and the type of information that's implicit in data protection principles. So I suppose our focus is on novel and emerging forms of data processing. As you say, where the state of the art is progressing rapidly, and the ability of data to yield insight about individuals rapidly changes with that state of the art. So I thought it was particularly helpful to give the examples of genome sequencing or human samples, which can be unstructured. They can be found, well, they're found in a natural medium and have to undergo processing to extract structured meaning. And I suppose at the point in which they are in their natural and structured form, they're also ambivalent about whether humans can have a cognition of their meaning. And similarly with neural networks, it's a great example where a great deal of the information within those systems either isn't really intended for human cognition, or it's simply impossible to be understood by humans given its nature. They're both good examples, I think, because they raise considerable concerns about the risks to information privacy and data protection, and the tension between the type of information and the assumptions about appropriate processing can be a significant potential obstacle to their adoption and development. I suppose what that made me think is that, I mean, depending on the type of information, the type of processing, that might sometimes be a good thing. Other times it will be something that's deeply problematic in terms of the application of data protection law. So I suppose where that leads me in terms of the questions that I'm building up is to ask whether information as an object of regulation should really be seen as a second conception of information within the GDPR, rather than being a conception of appropriate forms of information for processing. So it's necessarily, the second concept might necessarily be trying to exclude some things that do fall within the applicability criterion concept. And that might be in keeping with a purposive interpretation of the GDPR. So that's because the forms of data processing implicit in the data protection principles and other requirements of the GDPR reflect in turn not just a conception of information, but a conception of, I suppose, broadly appropriate data processing. There's many different principles that make that up, which would necessarily exclude, on your analysis, certain types of information from being processed at all. And that points, I think, in turn to some interesting questions for future research. So if some information is within the scope of the GDPR, but cannot reasonably comply with its substantive requirements as a result of the inherent characteristics of that information, there might be some context, I think, where that's deeply problematic, but others where it's desirable to rule that out. And the overarching question to you is, how do we separate those things out from one another? I suppose an approach that strongly problematizes any divergence between those conceptions is one that seeks a single uniform conception of information across the two. And such that if the substantive principles of the GDPR imply the processing of a certain type of information, that must in turn be the type of information to which the GDPR applies. And the problem that I'd want to raise with that stronger view is that although it's attractive in terms of coherence, some of its consequences should give us pause for thought. So if a novel form of data processing involves information which doesn't conform to the concept of information implicit in information as an object of regulation, then that can lead us on a sort of strict coherence basis to conclude that it must therefore not have been intended to fall within the scope of the GDPR. The risk of that in turn is that problematic types of processing whose very nature violates the principles of data protection could then be interpreted to fall outside its scope entirely, where there's no regulation or protection to be had in relation to it. And it seems to me that some of these emerging technologies might be problematic in some respects, but need regulation in others. And some way of kind of being half in and half out is where the answer might lie. So it's, I suppose, a form of argument from impossibility. If the regulation can't require the impossible from data controllers, it can't really apply to that type of information. And I think that end of the spectrum might be an error, because there are good reasons sometimes to value attention between the two concepts. And if the GDPR needs to be future-proofed then against rapidly emerging novel technologies, it seems that it needs to cast the net wide in terms of the sorts of information it regulates. And in setting standards, perhaps only a subset of that data processing can be possible. So you find this sometimes posed in places that if machine learning can't be transparent in the way that data protection principles require, should it be being permitted at all? And I suppose the applicable thought to human tissue samples would be, if you can't disclose it to the data subject on a cost-effective basis, should you be storing those things in biobanks? And of course, there are great reasons to use both of those technologies. So that's the point I want to raise in relation to that. A related point then that occurred to me is that it might also sometimes be a good idea to have processing that can't fully comply with one of the data protection principles. And there's a tension in this. So on the one hand, the GDPR is a device for regulators and has an enforcement regime there, but it also gives rise to individual rights to compensation for material and non-material damage if there's a breach of one of the principles. And it made me wonder whether types of processing that don't fit easily with the object of regulation conception might create for us a form of strict liability for damage resulting from those technologies. And could that be a desirable, if unintended, consequence of this tension? So that's within that, there's a set of questions and thoughts. It's an excellent paper and presentation, and it's provoked so many thoughts for me. So just to finish really by thanking you again for the excellent presentation, and looking forward to the Q&A.
Well, thanks, Oliver. That was a really interesting array of questions. Dara, before we turn to Q&A, would you like to respond to some of those? You're on mute, Dara.
Yes, sorry about that. They are really excellent questions. I'd like to start by saying, as this is such an underexplored issue, the analytical, or the approach we took so far was highly analytical, and I would say useful for identifying issues in data. It's considering data protection law from the perspective of information is useful for identifying problems in data protection law, but it shouldn't be taken too literally that there were intended to be two concepts of information in data protection law by the regulator. I don't think the regulator thought about it at all, if I'm honest. The differences emerged, I would imagine, over time by virtue of the fact that data protection law has been designed to be exceedingly flexible to address, as I think I said in the presentation, address or to provide some protection where depictions of individuals are capable of posing risks in the information society. The range of risks is not defined in advance. The range of forms of depictions is not defined in advance. This is some kind of, we don't have a good word in law, I think, for describing an area of law or even a piece of secondary legislation like the GDPR, which attempts to almost extend the array of protection for rights which can be impacted in the information society by information on its own. So what I mean by that, I think I was rather unclear. What I mean by that is we have words like primary law and secondary law. Data protection is something like sub-constitutional law. It's the framework through which we're attempting to extend all the rights we already have and map them into the information society. So we need this extremely flexible applicability criterion because the technology changes so fast, because the social contexts in which information processing has an impact change so fast, that if this broad applicability criterion wasn't there, the flow of technology and social change would simply route around the obstructions posed by data protection law to change. In that regard, I wouldn't see this idea of two concepts of information as currently offering normative answers to any of the issues posed by new technologies to individuals' rights. But what I would say is that it points the direction to some issues that might need to be solved. And in that regard, I think, Oliver, exactly what you said about the purposive interpretation of data protection law is really important. It's not only, I mean, it's not something I touched on in the presentation, but each of the concrete provisions in data protection law is also designed to be flexible. There are then supplemental flexibility and interpretation mechanisms built into the legal architecture that allow the law itself to adapt. So even the concrete provisions, even the black letter text, to be adapted to legislative change. And I mean, we struggle, I think, in data protection law to understand how far these principles can be adapted. Sometimes it looks like these principles actually almost have no form at all, as they're capable of being adapted through these adaptation mechanisms to such degrees that they almost don't resemble the original black letter principles as they appear in the law. That's probably an over-exaggeration, but they can be incredibly flexibly interpreted. The question is whether, I think the question is, once you identify a normative issue that emerges, that is well observed as a consequence of the fact that there are two conceptualizations of information in data protection law, the question is how you then solve that issue. Some of these issues, and I think most of the issues that I highlighted today, are probably easily reconcilable with they're easily solvable by adaptations or interpretations of existing principles in data protection law. So for example, and I think one of the points you raised there was whether it's possible to actually disapply certain principles in certain given cases. There is certain jurisprudence, and it's not quasi-jurisprudence, it's a very, very authoritative body has provided guidance that it is possible in certain cases to disapply principles. That guidance it's limited, I think it came out in about 2007 and it's never been repeated, but it is there. And this would be, for example, the case in relation to providing data subjects in certain cases with copies of their biological sample. There are certain cases in medical research in which this really doesn't make very much sense at all. I think these solutions that are premised on the interpretation of existing principles in data protection law, or premised on the adaptation of existing structures in data protection law, however, are only going to take us so far. There is a value, a unique, not a unique value, a value apart from the, there are values inherent in law which don't relate specifically to the concrete principles of law. So one of the values is that legal systems should be coherent and should be understandable. There is a risk with playing around too much with interpretation that a legal system simply loses this coherence and understandability. And in that regard, I think there are other sets of solutions that will become necessary over time. For example, legislative change. I don't think that over time it's going to be particularly feasible to have one framework of data protection law to deal with all the possible manifestations and characterizations of information. You're probably going to need various different approaches and various different substantive principles to deal with the specific characteristics of each different type of information. And to a degree, you already see this in other areas of information law, and some areas of information law very, very closely connected to the GDPR. So or other areas of data protection law, if you will. E-evidence, some of the jurisprudence which has just come out from the Court of Justice of the European Union, for example, La Quadrature du Net, in which they provide very, very fine-grained clarifications of how different types of information should be treated, etc., etc. I think this is a precursor of what's to come and might well be seen through the perspective of the concept of information. I think actually with that answer, which went a little bit around the houses, perhaps I've sort of addressed your second question too, or would you be looking for more?
No, I think that's really helpful. Can I bring on to that point about whether this could be I suppose it's a sort of serendipity that it might create a strict liability regime for individuals who suffered damage from novel processing.
So in relation to strict liability, it could, but strict liability is, it's a harsh sanction. I mean, you would want to be careful about how you define the cases in which non-compliance or specific non-compliance with a data protection provision creates strict liability and how that strict liability is perceived. Of course, every case in which a problem emerges from differences in conceptualizations of information has to be treated separately. There are good reasons that strict liability might be a useful response in certain cases. There have been in the past strict liability provisions relevant in data protection law in certain national data protection legislations, and they were put in there with specific normative thought behind them. Having said that, strict liability is also a great way to absolutely kill innovation. So, for example, the case of machine learning, it would be an option, so a legitimate response in law to simply say, well, if the information that's being processed in these systems is not accessible to human understanding, human perception, then these systems are illegal, and anybody engaging in this kind of activity, regardless of why, the whys and wherefores, is subject to strict liability principles. Well, that would do a really good job of killing research into neural networking technologies or similar technologies, or potentially, offshoot technologies, without really considering the normative situation behind. I mean, these are also technologies which can serve great goods, and it was never the purpose of data protection law to function as an obstruction to innovation. It was rather to find a good balance in any given case between innovation and the protection of rights. So I would hope that strict liability is not where we jump when seeing some kind of discrepancy, but in certain cases it might provide a really good response to technologies or processing contexts in which the risk to rights is simply too large to permit.
That's great, thank you. Is this a reflection then of the GDPR being sort of technology neutral, that it struggles to choose which technologies should be the subject of those sort of heightened obligations and those which should not?
I mean, I think to phrase this correctly is difficult. I think the idea of technology or technology neutrality is, I don't want to say, it should be taken with a grain of salt. It's impossible to be technologically neutral in law. Law exists in a social context. A social context currently is defined by information technologies, or can be said to be defined by information technologies. They're not definitive of everything, of course, but they are definitive of the age in which we live. And in that regard, the effort of the GDPR to be technology neutral is eventually doomed to failure. I think what the GDPR tries to do is simply to avoid preferencing one set of technologies over another, or to avoid preferencing certain specific economic interests over another, and to avoid having a regime which is specific to one or another technology such that it actually skips protection. So yes, I mean, in a way, of course, you're completely right. The fact that certain principles in the GDPR are difficult to apply in relation to certain informations does imply that the GDPR has certain limitations on its technology neutrality. But the concept of technology neutrality itself is contextually limited. I mean, this is the if you look back at the history of data protection law, this is the trajectory that, I mean, this has been just proved time and time again since the early 1970s. There's a really nice article by Victor Meyer-Schönberger where he discusses the different generations of data protection law and how technological change required legislative response to produce a new generation of data protection law. Yeah, so I hope that's sort of vaguely in the ballpark of the question.
Well, thanks very much indeed. We now have got some questions from our audience, and the first two are kind of interrelated questions. So they are whether the difference between information qua applicability criterion and information qua regulatory object is the same as the difference between an in-principle application of the law to the object and an in-practice application of the law to the object. That's one way of formulating the question. And then the same questioner follows up to say, is the worry that the GDPR literally has two concepts of information, or is it rather that it's open to a broader kind of information in the applicability criterion level than it actually gets down to regulating in its concrete provisions? We can't hear you.
So I think the second formulation is really quite apt. It's I wouldn't put it in terms of a worry. I would put it in terms of a perspective. I think also, to go back to Oliver's initial question, it was an inevitability that a law that is intended, a law whose application or the application of which is related to risk, is inevitably going to struggle to put together or to manifest its intentions in concrete provisions, simply because risk is a concept that is far too fluid to put down into some specific set of provisions to be followed to ameliorate or deal with that risk. So yeah, I think the perspective I want to offer is that the GDPR contains two different. If you look at the GDPR from the perspective of information, it's analytically useful to regard it as containing two different concepts of information which fulfill two different roles. The first is as an applicability criteria, and the breadth of interpretability of this criteria is very broad. And the second is as an object of regulation, which is much narrower. And then to put it as John Surratt, the questioner puts it, essentially, the first criteria is open to much broader kinds of information than those encompassed by its concrete provisions. Yeah.
We have a follow-up question to that, and I'm just wondering if the person who's put the question would like to put it themselves, because
yes.
So I'm just going to see if you would, John, you put the question again. Do you want to just unmute yourself? Is that possible, Gayatri? Can we unmute one of the participants to let them do the question?
Yes, I've just given permission to do that.
Okay, great. Thank you. I think that might be easier than me putting the questions that I think might make for an interesting conversation. John, do you want to go ahead and put your question?
Yes. Can you hear me?
Yes.
Yes, you can. Yeah, my follow-up question just quickly was, in that event, is it feasible to think not merely in terms of two concepts, but effectively as many concepts as there are applications of various, as many concepts as there are different attempts to regulate different creatures, different legislative beasts out there in the wild?
Yes. Absolutely. This, as I said, this was a preliminary analysis. You could go further, far further and far deeper, and consider the degree to which there are different concepts of information which relate to each specific concrete provision in the data protection law. There's no guarantee that they relate to exactly the same thing. Provisions are drafted by different people in different times for different reasons, et cetera, and have very different histories. And you could go further and then consider whether jurisprudential interpretations of these provisions have served to alter the concepts of information in which they embody in relation to one or more different types of contexts. There is a second layer to that question that goes in a little bit of a different direction, and that is, in our analysis, we used a framework for mapping the boundaries of the concepts of information in data protection law, which was drawn on the analysis, or which drew on analysis of concepts of information in other disciplines. Concepts of information in all disciplines relate to their function in that discipline. So they don't necessarily reflect some truth about the existence of information in the world that is universally relevant across all disciplines. They each fulfill a function, and the concept of information in data protection law fulfills a function as well. And I think it would be really, really interesting to look at whether you might identify a sui generis concept of information in data protection law relevant, or whose boundaries, or the boundaries of which are traced in relation to risk in the information society, as opposed to in relation to some objective qualities of information that have been identified relevant to other disciplines. And I can give a first insight, or not insight, I mean sort of extend the thought a little further. So there is case law concerning data protection which highlights the possibility for data protection to prevent risks in relation to chilling effects in information processing systems. So Digital Rights Ireland is one case, for example, in which this concept of chilling effects appears. I think it appears in Privacy International very recently, but it might appear in Quadrature du Net. Of course, for chilling effects to emerge, there is actually no need to process information. You simply have to have the presumption that information is processed. So I think there's an argument to be made that you could identify a sui generis concept of information in data protection law, which relates solely to risks that emerge as a result of information processing in the networked society, which don't necessarily map to any given boundaries of information or concepts of information as you find them in other disciplines. And this idea of chilling effects is one example of this. And the idea that risks can be emergent out of information processing networks, whereas those risks themselves don't necessarily need information to be processed. And you might also think in more concrete terms, you could think, for example, about dummy camera systems. So you could conceivably identify risks to individuals in the information society emerging out of the fact that those individuals are subject to dummy camera systems. The dummy camera systems change the ways they behave and can cause risks, just as can cause changes of behavior which are normatively as undesirable as if those were real cameras. The function of those dummy camera systems is based on the assumption that individuals understand the function of real camera systems and the information processing they involve, even though those dummy camera systems don't actually require any processing themselves. And the question is then, could the concept of information in data protection law extend to a context in which information has never even been, or as we would normally understand it, ever been processed? And I had a brief look as to whether I could find any jurisprudence backing this up in any way, because the only cases in which chilling effects have been mentioned are cases in which information has genuinely been processed, albeit not necessarily in relation to any one or another given individual. And I did find some national transpositions of data protection law which do contain provisions related solely to dummy camera systems. I think the Norwegian data protection law has one, and a certain German data protection authority guidance dealing with dummy camera systems, which suggests to me that at least this is not completely outside of the scope of the sphere of data protection law, even though it is quite an unusual idea. I wanted to put that forward because I find that idea very interesting, and I thought it followed on quite nicely from John's question. Yeah, even though it is a very strange idea, I'm not suggesting data protection law from tomorrow should be applied to all the situations in which no information is processed. That would not be good.
So just one thought, I mean, it does seem to me that this really is a question of statutory interpretation, and largely what you're suggesting, if I understand it, I'm not a data protection lawyer, is that we would interpret the concrete obligations created under data protection law, recognizing that in circumstances where it's not possible to do so, we therefore have to have a narrower understanding of information. So there's a sort of a premise there, which is that this provision, this obligation being imposed, and it's kind of the reverse of Oliver's question, this obligation that's being imposed upon you couldn't be imposed upon you, albeit if it wouldn't actually work, it wouldn't be possible for you to comply with it, given the character of information you're dealing with. I mean, would that resolve a lot of the difficulties? Because it does seem to me that a lot of your 3 examples are drawn from, in relation to the regulatory aspect of definition of information, are drawn from whether it's functionally possible to apply the existing concrete obligations to that particular form of information.
Yes, completely. As you know, I think that's very much the reverse of Oliver's question. I would only say that in any, the data protection law has been deliberately designed, the concrete obligations have been deliberately designed to be flexible. It's probably this flexibility is best embodied in the concept of the risk-based approach, which so the degree to which the risk-based approach is, or the flexibility of the risk-based approach in relation to coming up with novel alternative conceptualizations of how provisions should be applied is the subject of some disagreement. Some is an understatement, but of disagreement. So to simply say for every one of these contexts, we should just disapply the principle is not likely to meet with universal approval. But I see the legitimacy of the ability in certain contexts where one or the other principle simply doesn't make sense, that they might be disapplied. Whether the authorities, the data protection authorities, for example, or the European Data Protection Board at a higher level, has the executive authority to really engage in that, in such a disapplication of statutory law, is, I think, a question that's open. But they've suggested that this might be possible. And they have also added, so to speak, principles to data protection law. So binding corporate rules, for example, didn't exist until the Article 29 Working Party brought them into existence. And they've been very flexible with how they've used this power so far. So I would hope that I would also add that the 3 examples I've provided, these aren't, I didn't say anything about the magnitude of the problems these were causing in society. They were examples chosen to demonstrate the relevance of the analysis, but none of them thus far has exploded into being particularly socially problematic. I think maybe the exception of machine learning on neural networks. But I would hope that in the example of medical research and biological samples, for example, if it came to pass, and I think this is very unlikely, that a whole load of data subjects started inundating medical researchers with no particular reason for copies of their their genomic sequence, that there might have to be some sensible approach taken by data protection authorities so that the medical research infrastructure didn't break apart. Yeah, and having said that, I think even within each of those specific examples, there's a need for subtlety in the disapplication and application of provisions. So every circumstance will be different. While I say tendentially, for example, there is this obligation to provide a copy of biological samples imposes disproportionate obligation. There are numerous different contexts in medical research in which biological samples are used, and it is not the case that in absolutely every single one of those, this is a meaningless or disproportionate obligation. So, for example, there are cases or there are forms of research which deal with rare diseases. for which there is a highly limited amount of samples available. Now, in certain of those cases, it might fulfill a really useful role for an individual to have access to their, or have the ability to have their sample or a copy of their data transferred to, for example, especially if that data isn't even available to that individual anymore. Say if it was a sample of a tumor that they didn't have anymore, that it might be very useful and desirable that individuals had the right to have that data, say, for example, to use their right to portability and have that data transferred to another researcher. So I think there is a degree of flexibility that will always be required, and that mandates against any particularly strong legislative response that goes across too many areas, but which is based on specific presuppositions as to the normative balancing in one given case.
Well, thank you. Oliver, anything you'd like to follow up with?
Only to ask whether, so the question of excessive burden comes up in relation to quite a few of the examples. And I wondered whether, in many ways, that's only a question of degree rather than anything else. I was thinking of the example you gave of data subject requests, which could impose so great a burden. I mean, for most data controllers, if a large enough proportion of their data subjects put in a subject access request, then actually complying with data protection law would make the processing unviable. And like, so how much is this a reflection of some of those sort of underlying vulnerabilities that the GDPR exposes any data controller to?
Yeah, I don't see that. It's probably something I should have made explicit in the presentation. I don't see that using the perspective of information to identify problems is necessarily restrictive of there being other approaches to identify the same problem, or other approaches to identifying the same problem. And in that regard, I think you can look at problems or other problems in relation to the same issue. And I think you can certainly look at the excessive burden and the presumption that these weren't intended to apply an excessive burden on data controllers in any number of different ways. You can get to that conclusion, and you can look at any number of different processing contexts in which this example of excessive burden comes up. We've tendentially, just as we haven't looked at the concept of information particularly extensively in data protection, and we don't have a good look at that, we also haven't got a particularly good grasp on the internal function of data controllers, or the wide variety of data controllers, and what is excessive and not excessive in relation to the normal data controller. We happen to have done an amount of work last year in which we went into certain data controllers to test a data protection impact assessment methodology that we developed. And it was eye-opening for me to learn how a number of companies, at least the ones we saw, go about structuring internally their data processing, and where this has come from, or where they're thinking about it has come from, and how disorganized it is. So I think the idea of excessive burden can arise from a number of different causal reasons, and that there are different conceptualizations of information in data protection is just one way, one causal reason, and one way to perceive this kind of issue.
Well, thank you very much. Thanks to Dara for a fascinating presentation, and to Oliver for his responses, and to all of you for attending. We will be having one last area discussion group this term next Tuesday, and John Bowers, the current principal of Brasenose College and an eminent UK labor lawyer, will be presenting on the topic of accommodating difference. How is religious freedom protected when it clashes with other rights? The discussant will be Nazila Ganay, who is a presenter of the MST in International Human Rights Law at Conted and a member of the Border Bonavero team. So please do join us for that next Tuesday at 12:30. That will be the last discussion group for this term. And then finally, just to thank Dara and Oliver again for a really interesting conversation, and to all of you for attending, and keep well and stay safe. Bye.
Bye-bye, everyone.